and as you know, you're allotted 20 minutes. How much time do you wish for rebuttal, sir?
5 minutes, Your Honor.
I'm sorry, 5 minutes?
5 minutes.
Very, very good, sir. Thank you. Whenever you're ready, please proceed.
May it please the court, my name is Ezekiel Lugo and I represent the appellant, John Gilby. As I noted, I would like to reserve 5 minutes for rebuttal. And this morning, we're asking the court to reverse and remand the order on appeal for further proceedings because the main issue in this case is that the complaint did not allege for a basis for venue in Hillsborough County. And
is that required, Mr. Lugo?
Under cases like the, and I've had trouble saying this name, Gutsmaker versus Gutsmaker, the Florida Supreme Court, 1988, that is required. There's also case law from this court dating back to 1970, James A. Knowles, Inc. versus Imperial Lumber Corporation. Judge Silverman wrote about that requirement in Procacci versus Harley out of this court in 2012. The Fifth District Court of Appeal has also reversed a venue order where the complaint did not contain sufficient allegations of venue, and the defendant filed a motion to dismiss that was not supported by an affidavit. And the Fifth District in that case, and that's Pozo versus Roadhouse Grill, 2001 Fifth District Court of Appeal. The Fifth DCA wrote that because the plaintiff failed to meet its initial burden of sufficiently pleading venue, the attorney's motion to dismiss was sufficient to challenge venue. So
it's my understanding, though, if I may, Mr. Lugo, my understanding that usually these are raised as affirmative defenses from the defense. And there's a lot of cases out there that talk about that, but I don't believe that there's any rule requires that you have to allege that. Am I wrong?
Your Honor, there is no rule of civil procedure that directly requires that. But I point again to the Gutsmaker case from the Florida Supreme Court, where the Florida Supreme Court was clear, and I'm trying to locate the case to read the specific sentence that we're relying on, the part of the opinion we're relying on. Florida Supreme Court at 520 Southern 2nd, 575, on page 578 of the opinion. They said, the plaintiff must allege in the complaint a sufficient basis for venue. And the issue in that case had to do with the fact that the trial court and the Third District Court of Appeal, they both relied on information that was not pleaded in the complaint.
And I understand that, Mr. Lugo, and that's why I wanted to pull it up. But wasn't that dicta in that case? They didn't come out and they're holding to say, this shall be done. My understanding is that that was just pure dicta.
Your Honor, respectfully, it was not dicta. It was central to the court's decision. Like I said, that the trial court and the Third District Court of Appeal, they both relied on the fact that the husband, and it was a divorce proceeding. And in that case, when the wife filed a motion challenging venue, the husband filed an affidavit saying, well, we also have this property in Miami-Dade County that's going to become an issue in the case, and I plan to amend my pleading later on to address the division of that property in the case. Trial court said that was enough to cite venue in Miami-Dade County. Third District Court of Appeal agreed. When it got to the Florida Supreme Court, they addressed that issue head on as a threshold matter. If you look at Het Notes 1 and 2, they say as a threshold matter, notwithstanding the legal significance of the term property in litigation, which was the part of the statute that the Florida Supreme Court was analyzing.
But if I may, Mr. Lugo, wasn't that a dissolution case about property and litigation, right?
It was a straight divorce case. There was no allegation in the pleadings about the division of the property. And that was the fundamental error that the Florida Supreme Court addressed first head on Het Notes 1 and 2. And that's why the Florida Supreme Court explained, well, the plaintiff must allege in the complaint a sufficient basis for the venue selected, because the plaintiff had not alleged anything in the complaint regarding that division of property. That could not be a basis to cite venue in Miami-Dade County.
But my understanding was in that case, the whole question was whether there was property at all, which is far different from what you're trying to make argument in this case. And help me out, Mr. Lugo.
Yeah, so the question in that case had to do with the interpretation of section 47.011, which is the same issue, same statute what we're talking about here. It was cited on the first paragraph of the motion to dismiss. And as the court knows, that statute says that action shall be brought only in the county where the defendant resides, where the cause of action accrued, or where the property in litigation is located. In Gutsmaker, the husband was making a big deal that venue was proper because that's where the property in litigation was located. But there was no allegation in the complaint about any division of property or any property being in dispute. So the Florida Supreme Court started by explaining that, and then they went ahead and addressed the issue in the certified question about the interpretation of that phrase, the property in litigation is located.
Okay, and if I may, Mr. Lugo, because you're making a category statement that there's case law right on point that requires that, but I'm pulling the file right now, and in that case, the Supreme Court at page 577, their whole thing was, we find error in the determination by the courts below that the pleadings were sufficient to establish property as an issue in this case at all. This is far different from what these are distinguishable, and a lot of the language that they said was, at least in my opinion, pure dicta, which then begs the question is that, do we have any rule that requires that? Is there anything in some matters that would require that specific pleading requirements?
Okay, well, respectfully, our position is that Gutsmaker does support that point. I also cited the other cases from the Florida Supreme Court, from the 2nd District Court of Appeal, and from the 5th DCA, in particular, the Pozo case we're relying on. But I would also point out that the Florida Supreme Court, as part of the rules of civil procedure, they include forms at the end of the rules. And there are 3 forms for complaints alleging negligence. One of them was cited in the reply brief, the one at 1.945 has to deal with motor vehicle negligence. That form complaint makes it clear that facts regarding venue have to be pled per the form complaint. It includes a sentence that says, on or about blank date, defendant owned and operated a motor vehicle at blank in blank, Florida. Similar requirements are in the form for a motor vehicle accident involving multiple defendants at 1.946 and at 1.94151 dealing with premises liability cases where the location of the premises has to be included in the complaint. And that's far different than what was alleged in this complaint. This is a case about hiding the ball. If you look at the complaint starts with a heading.
And if I may, Mr. Lugo, I think you're making argument as to what best practices as a requirement, but that requirement exists at most, and the dicta in these cases. But let me steer you another. Let me just ask you this, sir. As soon as after the lawsuit was filed, okay, and then when you asserted venue, that venue was improper, did you provide, was there anything on the record that you could show, any evidence to support that allegation that venue was improper in Hillsborough?
Yes, Your Honor. So the argument was based on, first of all, the pleadings, the lack of pleading of venue. And as I was saying, the complaint starts with a heading, big, bold, uppercase letters that says jurisdiction, venue, and identification of parties. So the complaint says it's going to address venue. The only allegation there that's remotely relevant, paragraph 2, at all times material, defendant John Gilby was and is a resident of the state of Florida. Nothing there ties them to Pinellas County.
No, and I understand that, Mr. My question is that after that, when you decided to challenge us saying that venue is improper in Hillsborough, should be in Pinellas, was there anything submitted to the court, an affidavit, sworn under oath that the accident took place in Pinellas? Was that done before the hearing on the motion?
Before the hearing, no, Your Honor. So the defense counsel reached out to the office of the plaintiff's attorney and asked, hey, is there opposition to this motion? The attorney just said, I'm going to look into it. And then that was on September 29th. The hearing was on November 1st. And the attorney begins the argument by telling the judge, look, I filed the motion. I haven't heard any opposition. I gave them a call and he said he would look into it. And his argument ends there after he makes the point that the complaint doesn't include sufficient allegations. At that time, the plaintiff's counsel for the first time brings up the argument that, well, the motion is facially insufficient because there was no affidavit filed contemporaneously with it, and cites two cases that had not been disclosed to the defendant before. So that's the context in which the motion was filed and set for hearing. Once that was raised, the judge said on the record that she would allow the attorneys to exchange the case law, file any additional case law, and send that to her, not filing it with the clerk. But she made it clear, page 852 of the appellant's appendix, that she was not going to continue the case. She was not going to have another hearing. It was just the attorneys were going to provide the case law, and that was it. On page 54, she again indicates, I don't want a big project here, memos and stuff like that. So she wasn't contemplating any additional argument or anything like that. Once the case law is provided, or I guess exchanged, the defendant submits an affidavit and a case where it was a venue issue that was reversed, and there's no reference to an affidavit. So that's the state of the evidentiary portion of the case. But there was no citation to any rule that requires a contemporaneous filing of an affidavit with the motion to dismiss challenging venue. The case law says the motion has to explain where venue would be proper, and the motion in this case did that. The motion indicated that venue would be proper in Pinellas County because that's where Mr. Gilby resides, and that's where the accident occurred, which the complaint didn't specify. It just says the accident happened at the intersection of 4th Street North, turning right onto 5th Avenue North, without indicating any city or county where the accident took place. At the hearing, though, the defense attorney did point out to the judge, well, judge, look, the summons was directed to an address at Pinellas County. So when faced with this issue about the evidentiary problem, the defense attorney points out at least to the summons, and both the application for the summons and the summons itself are both directed at an address in Pinellas County, indicating that there was no relation between this defendant and Hillsborough County. And I would point out the case that the plaintiff cited, the Inverness Coca-Cola case from 1955 in the Florida Supreme Court, that is a case about waiver, where the defendant did not plead improper venue, either in the motion to dismiss or a motion for summary judgment stage later on. In that case, the complaint included some allegations regarding the location of the defendant's operations. Florida Supreme Court did not analyze the statute at issue here, 47.011, or its predecessor. The court held that the denial of summary judgment on the issue of venue was proper because the defendant failed to plead venue in a motion to dismiss or in an answer. That's different than this case. Here, the plaintiff has now conceded, page 24 of the answer brief, that Gilby's motion to dismiss satisfied the burden of pleading venue was improper. So this is not a waiver case like the Inverness case. The court also said, the Florida Supreme Court said that it wasn't holding that if the defendant had properly pleaded the venue privilege, either by motion or answer, that it would permit the result to stand. Well, here it's been pled. It was raised sufficiently in the motion. It's included as an affirmative defense in the answer. The plaintiff also concedes that the affidavit would have carried the defendant's burden of producing evidence on page 27 of the answer brief. And again, I'll point out that when the Supreme Court later did interpret Section 47.011 in the Gutsmaker case, it reversed because the complaint in that case did not include allegations regarding the property at all, which was the basis for denying the venue motion in the trial court and affirming.
And Mr. Lugo, you're about to get into your 5-minute rebuttal. Feel free to go forward if you wish, or if you wish to reserve the remainder, whatever is your pleasure.
Your Honor, I'll just repeat our request that the entire order be reversed and remanded for further proceedings, and I'll reserve the rest of my time.
Very good. Thank you, sir. All right. Mr. Gowdy, whenever you're ready.
Excuse me. Good morning. May it please the court. This entire appeal is about the burden of pleading and proving in the context of venue. And the plaintiff below and on appeal, I'm sorry, not the plaintiff, the defendant rested his entire argument, both in the trial court and in the appellate court, on the flawed premise that a plaintiff has a burden to plead venue in the complaint. You've heard it this morning many times. And that flawed premise is, you pull on that and the entire argument collapses. And before I get to, we've already heard there's nothing in the rule or the text of the statute that requires this. And so where does Mr. Lugo point to? He can only point to one place, case law. And before we get into all that case law, I want to point out to the court that none of the cases that Mr. Lugo is relying upon today or in his brief were presented to the trial judge. And I think it's important. I don't think you need to get into all of this because you just got a simple preservation basis to affirm here. Mr. Lugo says in his brief, oh, you don't have to present in the trial court all the cases you're going to present in the appellate court. I don't disagree with that proposition. If you present case A in the trial court and then you present cases B, C, D, and E in the appellate court that say more or less the same thing as case A, fine. But here we had no cases presented to the trial judge. And the context of the hearing transcript, if you review it, is, you know, as Mr. Lugo's pointed out, defense counsel was taken a little by surprise, didn't know about the cases that the plaintiff's counsel was going to cite. So the judge, he said, you know, the trial judge very fairly said, I'm going to give both sides 2 weeks after this hearing to submit case law and written orders to me. That was it. She didn't say present evidence. She said, I'll give you time to present case law and written orders. And in response, we put the letter in our supplemental appendix that was submitted to the judge. The defendant gave a single case called Omrick, a 1975 case from this court, which you won't find in Mr. Lugo's brief because it has nothing to do with pleading or proving venue or who has the burden of doing that. So here was a trial judge saying to defense counsel, show me the cases that say that the plaintiff has to plead venue, because the plaintiff's counsel had presented 2 cases showing that the plaintiff did not have to plead venue. And there was nothing presented. And so I think on that basis alone, you can affirm. And just some of the other preservation issues we've got here is, I said that in my brief that the defendant didn't follow proper trial and appellate procedures, and we did identify in our answer brief what those were that weren't followed. First of all, there was never a request below or on this appeal for an evidentiary hearing. Thus, that argument or that request is now waived. Page 26 of the answer brief. Secondarily, defendant noticed this for a non-evidentiary hearing. Under case law, the trial judge would have committed reversible error had it received any evidence at this non-evidentiary hearing. That's page 34 of our answer brief. Now, the defendant's argument to this is, well, Section 90.104 of the evidence code does not allow a party to make allows a party to make a proffer. It does not allow a party to make a proffer whenever he or she wants. You can't, after the jury walks out, you don't get to make your proffer. Here, they waited till 2 weeks after the hearing and they made a proffer. And they didn't seek leave to do so. They didn't file a motion saying, hey, Judge, can we now have an evidentiary hearing? We realize we should have done this. Or Judge, do we have leave to file this affidavit? We realize we made a mistake. They didn't do anything like that. They just filed it. And there was a motion to strike filed and never a response. Even though after the motion to strike was filed and the affidavit was filed, there was a status conference. That's also in our supplemental appendix where this venue issue was discussed and defense counsel did nothing. So the issues just aren't preserved. And the last thing I just want to address on the waiver is on page 22 of the reply brief, the defendant says the circuit court may consider affidavits filed on rehearing. I agree. The circuit court has discretion here. May, not must. This trial judge is trying to move her docket. And I think we all know that there's a pressure for trial judges to get dockets moving in the state. And so she was trying to do that in an orderly manner. The last thing I'll just point out as far as the appellate procedure that we cited in our brief is that Rule 9.210B6 says that the conclusion must set forth the precise relief sought, not just the relief, but precise relief. And there's nothing in the conclusion seeking the reversal of the order striking the affidavit. If there's no questions on preservation, I do want to discuss the case law. Judge Kazan, you're right about goat markers being dicta. I think we've been very candid with the court and not overstating what's a holding. And now what we got in the reply brief was, oh, look at all these concessions about dicta. Well, if what Mr. Lugo says is a holding is in fact a holding, which I disagree with, then what we're citing is a holding too, and I guess you'll have to sort through all this. But I think the fair way to look at the case law is that there's a lot of dicta out there, and that's why you should ultimately return to the rules, on which I've heard no argument this morning that the rules require a plaintiff to plead venue.
And Mr. Gowdy, my understanding what the court did is basically, we all know that the defendant in these type of cases, they bear the burden to prove improper venue. So this could have been easily rectified with the filing of an evidence hearing is not necessary. The case law does not require that, but they could have filed an affidavit indicating, because they bear the burden, that setting forth that venue was improper. In this case, what the court concluded that regrettably, they didn't do that before the hearing. They chose to do that after, and the court basically said that because they failed to timely, and that's the operative word, timely provide sworn proof in support of their motion that venue is improper, that's one of the reasons why the court denied that. So this is in her order that set forth this. Not saying whether or not an affidavit should or should not be used, where an evidentiary hearing should or should not. But the bottom line in from the case law, when we review this, the burden is on the defendant to prove improper venue.
I agree. The burden of pleading and proving. And so our concession about them pleading it doesn't change the fact they didn't prove it. Those are two different concepts. And as you stated, Your Honor, that they did not file the affidavit before or presented at the hearing. They waited till 2 weeks after and didn't seek leave to do so. And I think the only way I might slightly part ways with Your Honor, I agree an evidentiary hearing is not always required, but had the affidavit been filed, then at that point, our side may have said, well, wait, we want to take the deposition of the affiant, or we want to cross-examine him, or we may want to come forward with some other evidence. But we never got there.
And I'm not suggesting that, Mr. Gowdy. I'm just saying, what is the requirements based on the cases before us and what the requirements are?
Right. And
that's what I was.
The requirement is the defendant has to both plead and prove. I acknowledge the case law and we're very candid with the court, the case law is less than clear about this. But I just did want to get into that, if I may. We heard a lot about the Goadmakers case from 1988 from the Florida Supreme Court. I agree that it's dicta, and I think it's been covered. It's covered in a brief. I'm not going to go over it. The case that we cite from the Florida Supreme Court is Inverness, and I've been candid in saying that that's probably dicta too, but not all dicta is equal. And the Inverness case is far more persuasive for a couple of reasons. First, this court just last year quoted this dicta from the Inverness court in its Nelson decision in 2021. And what it said is, it is of the very nature of venue that the plaintiff selects it initially, but need not plead or prove that his selection has been proper. And the burden of pleading and proving that the venue is improper, if such is the fact, is upon the defendant. I think it's a very clear statement. And I would like to point out that the 1955 Inverness Court, 4 of the 6 justices in the majority were the same justices who adopted the rules of civil procedure for Florida. We started those in 1950. And so if we're going to be into originalism and textualism, the justices who wrote Inverness are the same justices who adopted what is today Rule 1.10 B and the other rules that I've discussed in my brief. And there's not been a significant change in the wording. We laid that out. I provided the 1950 and 54 rules to this court in my supplemental appendix. And so if you're going to look at dicta, that's the best dicta we got. There is some different cases from the 2nd District. I heard my friend talk about Procaci that Judge Silverman wrote. The complaint on its face showed that venue was improper. Not so here. We can't tell from this complaint whether venue is proper or improper. It doesn't allege it. It could be proper, it could not be. It could be improper. And that's why Nelson, which was decided last year, is the more apropos case. I would also point out that Judge Silverman wrote another case for this court, and I'll probably butcher the pronunciation. I believe it's McConey from 2002. And there he said, it is the defendant's burden to plead and prove that venue is improper. And that case is more, and I've acknowledged this is dicta, but it's better dicta. That case is factually similar to our case because the defendant there also failed to present anything other than, and I quote, an unsworn motion with an attached document. Here we had an unsworn motion with no attachment. That's all was presented. And what Judge Silverman for the panel wrote is the defendant wasn't entitled to get a second bite at the apple, nor should the defendant here. The Knowles case from this court from 1970, again, it's dicta what they're relying upon. The issue was decided is whether a cause of action accrued in the county where the performance is called for by the contract, not where its benefits are enjoyed. Not relevant to our case. That's what the holding was about. And then we cited on page 19 of our answer brief decisions, Searle, BC Cook and Sons, and United Engines, all from this court in the 1980s that properly state what the rules of civil procedures state, which is that the burden of pleading is not on the plaintiff. The burden of pleading improper venue is on the defendant, and thus so is the burden of proving improper defendant, which the defendant did not meet here. I just want to address some points from the reply, unless the court doesn't have any questions on what I've said so far. There's a couple things in the reply brief that I'd just like to address. The defendant contends that case law can establish pleading rules. First of all, that's that would be incorrect if you're relying upon District Court of Appeal case law, because our Constitution in Article 5, Section 2A gives the Supreme Court exclusive authority to adopt rules of court, including the rules for pleading. So the defendant then reaches to a case called Stockton from the Florida Supreme Court that requires attorney's fees to be pled. That holding is completely consistent with the text of Rule 1.10b3. It requires a claimant to plead, quote, a demand for judgment for the relief to which the pleader deems himself or herself entitled. So if part of your relief is attorney's fees or cost or whatever it may be, you need to plead it under the rule. And Stockton is consistent with that. I will acknowledge that Stockton did not cite the rule. I think we're in a different era these days with our current Supreme Court, and I think I can say they would definitely look at the rule first. That's what they made clear in the Jackson case that I cite, that we apply these statutory rules of construction to the rules of procedure as well. And then another point brought up in the reply brief is the whole line of cases, dealing with personal jurisdiction. Venetian Salami is the most famous case from the Supreme Court on that. It does establish, that case establishes the framework for pleading and proving personal jurisdiction. Now the defense in their reply brief for the first time argues, well, hey, adopt this for venue, that this court ought to go out on that limb. First time raised in the reply brief. I would say the court should not do that for all the reasons I've discussed. That should be up to the Florida Supreme Court if we're going to make a ruling like that. I'd also like to point out that Venetian Salami was based, the holding there was based in part on Rule 1.07I, which today is its subdivision H, and was part of a 1980 amendment to the Rules of Civil Procedure. And what that provision states is when service of process is to be made under statutes authorizing service on non-residents of Florida, it is sufficient to plead the basis for service in the language of the statute without pleading the facts supporting service. So I think it's implied from that rule that when you're dealing with at least long-arm jurisdiction, you need to plead. So there was some textual basis for the Venetian Salami case. And I would note the committee notes expressly state that subdivision was added because of the long-arm service.
Very good, Mr. Gowdy. Do you want to wrap it up because you're getting close to your
Yes.
answer? Anything further?
If the court doesn't have any questions, the last point I'll make is there was an argument made in the reply brief about you couldn't do any tipsy coachman. We were consistent in the trial court in that we argued that the plaintiff does not have a burden to plead or prove venue. We're raising that same argument on appeal. We're just relying here, in addition to dicta and case law, on the statutes and rules. And I would ask you to confirm.
Very good, Mr. Gowdy. Well, thank you. All right, Mr. Lugo, I think you have about your 4 minutes for rebuttal, sir. Okay.
Thank you, Your Honor. To the response to the argument that we're only citing dicta and that Gadsmacher is dicta, there are other cases we have cited that have stated this rule and applied it. They're on page 11 of the initial brief. Woodson from the 3rd District Court of Appeal in 2019, Drucker from the 4th District Court of Appeal in 2011, and the Pozo case that I referenced in my main presentation from the 5th District Court of Appeal in 2001 that involved a complaint that didn't include sufficient allegations regarding venue. And in that case, there was a motion with an affidavit, and that was sufficient, and the order denying the motion to dismiss based on improper venue was reversed. So there's case law on point that supported the argument that was being made in the motion. The motion cited it had legal authority. It was not a case, but it was the relevant statute, 47.011, which is the same statute that was addressed in the Pozo case. As far as the timing of the affidavit, and whether that's a concern, I heard opposing counsel reference some of the arguments of the reply, but I didn't hear him address Florida Rule Civil Procedure 1.030, which says that except when otherwise specifically provided by these rules or an applicable statute, every pleading or other document of a party represented by an attorney need not be verified or accompanied by an affidavit. He didn't cite any case, statute, or rule that requires the affidavit to be filed contemporaneously with the motion or at the time of the hearing. And in this case, the plaintiff was hiding the ball when they drafted that complaint, and they omitted the facts about the residence of the defendant and the location of the accident. They did not disclose their arguments to the defendant before the hearing. If on that phone call they had said, look, we have an issue because you didn't file an affidavit, then the defendant would have been able to file that affidavit before the hearing. When that was brought up to the defense attorney's attention at the hearing, the response was to file the affidavit before the judge had made a decision. This is not a case where the judge had made a preliminary decision at the hearing and there already been an adjudication on the motion. The evidence was submitted before the judge made her final decision. And that makes this case different from that Loya Coney case that opposing counsel cites, where the request for the ability to file the affidavit was after the case had already gone on appeal. And the trial judge and opposing counsel are relying on the Inverness case. And I would again point out that to the extent that case relates to the timing of the evidence, the Supreme Court made it clear that it would have considered the evidence if it had been filed at the summary judgment stage if the improper venue had been pleaded in a motion or in an answer. And here it was pleaded in both. So if the timing is an issue, the timing should not have been an issue, even under the case law that was cited by opposing counsel and relied upon by the court.
Okay, Mr. Lugo, you are right up to your rebuttal time, sir. Okay.
Yeah, so we just request that you reverse and remand.
Very good. Thank you both. Really appreciate it. And this time, the courts will take a 15-minute